You're listening to the Immigration Lawyers Toolbox podcast, the podcast that keeps your practice sharp and your clients happy. I'm your host, immigration lawyer John Khosravi, and every week we're bringing you insights, tips, and real-world conversations with top immigration attorneys and industry leaders. Whether you're here to grow your practice, stay on top of the latest trends, or get inspired, you're in the right place. Ready? Let's go. Hello, fellow Toolboxers. Welcome to episode number 411 of the Immigration Lawyers Toolbox. Fan favorite, and one of my favorites as well. I always learn new things from it. Is the interview we do every month with Kevin A. Gregg of the Kurzban, Tetzeli and Pratt law firm. He's also a fellow partner at that firm, headquartered in San Diego. But more importantly for us, he's also the host of the Immigration Review podcast, a weekly podcast updating you all on federal litigation. He's kind enough to come on my show once a month to just fill us in on 3 or 4 top cases he thinks that we'll find interesting, because a lot of times not things I focus on. So I love the fact that he's here to fill in the gaps that exist there. And we have some fun banter in the meantime. Before we start, I want to remind you that, and just let you know actually, that the new issue of the Immigration Lawyers Toolbox magazine is out. Issue number 10, 7 great articles in there that's going to change your practice one way or another. You're going to learn good stuff, either on the business side, on the law side, and just how to be better, make connections with these attorneys. They're very friendly and happy to connect. So I'm really happy to do this. And now the time is to collect new articles for the next one. So if you're a lawyer and you got some niche area you know really well, take a look at the magazine, see how it is. And 2 or 3 page article will be great. Just email me info@immigrationlawyerstoolbox.com with an idea. I'll think about it, see if we've done it before, or there's something new that could be added there that colleagues would help, and I'll help promote you as well. Maybe come on the podcast, talk about it as well. But we'd love to have you. So please email me for that if you want to get involved with the magazine. Next issue probably come out in 2 or 3 months. It's trying to make it quarterly. It's tough. It's tough launching a magazine as a side job of my main job. So that's what we do here at the Immigration Lawyers Toolbox. We push ourselves to the limit. But I also want to thank the sponsor for the magazine and this episode, who does push things to the max when it comes to case management, which I'm sure you're all talking about. You think about it a lot, because case management systems are a key part of immigration law practice. Maybe you're drowning in spreadsheets, or even stuck with software that feels like it's from 2015. Well, our friends at eImmigration recently published an ultimate immigration software buyer's guide. It's exactly what I wish I had when I was shopping for our firm's system, with real comparisons of the features that actually move the needle. Head to get.eimmigration.com/resources. That's get.eimmigration.com/resources to grab your copy and pick like a pro. So go to get.eimmigration.com/resources, and they're kind enough, you'll have a link to see in the magazine as well. I did an interview with the founders about the new AI partnership they have, VisaLaw.ai, which is incredible, real game changer in our field. So you'll be interested in that. Also, I want to remind people that we have these long interviews you do, but we clip them all too. So if you're on the go, it's hard to listen to a full 20-minute, an hour episode. We have 1,000 clips right now of all these things that are really on topic talking points. So if you follow Immigration Lawyers Toolbox on TikTok, TikTok too, actually have a page on there. It's not very popular because it's too technical probably for you on TikTok, but it's on YouTube. That's the library we keep there. On Instagram, you just get the fresh feed of it. On our Facebook page, I think Instagram a lot of people are into. So follow there, and you just see the headline, the cover, and you know if it's a topic you want to listen to, and you get really down and dirty with the info we get. So if definitely follow us on Instagram is the main thing. I'll say Immigration Lawyers Toolbox. And then we're going to talk about Circle as our community page, but I'll talk about the mid ad, if you will. So none of the information provided here is intended as individual legal guidance. Please consult with an attorney. But y'all know that already. Let's get the show started. Hey, Kevin, thank you so much for coming on the show again. Appreciate it.
Hi, John. Great to see you as always. Great to do the what are we? September? Gosh, I don't even know.
We're in September.
Do the August cases. Yeah.
There's some good stuff, I think.
Bangers.
I think you have some positive stuff happening.
You're absolutely right. I do. And I've got, I go through my cases there's always more. There's usually more positive than just the 3. Usually I keep the 3 on your show. And so actually I did pick 3 positive ones this time, although I cannot help but also talk about a 4th, a negative BIA decision, because I just think it's so important. And the BIA is being prolific in their publications. They clearly want me to talk about them. It's kind of embarrassing, BIA. You're kind of desperate. And so I talk about them so much on my show because I have to do every one of their decisions, but I never talk about them on your show because they just never do anything non-citizen friendly. And they didn't do anything non-citizen friendly last month, but I'm going to talk about their case It's so
I can't
important.
wait. Let
But
me guess.
yes,
We haven't prepped this, but is it the one about unusual hardship, extreme hardship?
it's not that, although
It's
that
even
one's
worse than
brutal
that.
too. This is the isomer one. I got so much beef on this. But yes, that hardship one was also brutal. Just continuously moving the ball on that. But on the other hand, yeah, that case, I do believe that's obviously an approvable case, the
Mhm.
one that they said it didn't cut it. But it's also not. I mean, the real enemy to me is that Congress created this ridiculous standard, got rid of suspension of deportation in 96, 97. I mean, cancellation, I do believe maybe it's my starting out at the immigration court bias, but like non-LPR cancellation is supposed to be hard to get. That said, that decision that's an extreme decision, extreme and exceptionally unusual, I would dare say.
Would that standard come through for 601s, or is that specifically for cancellation?
No, no, it was specifically for cancellation, and that's part of it. That extreme, exceptionally unusual hardship for non-LPR cancellation is more than extreme hardship for 601s, 601As, and the like. And that's kind of always been the correct legal analysis of the board. Like it's got to be higher than that,
Yeah.
for example. But
I mean,
no, not
yeah,
that
that's so
case.
the fact that even when it appealed that, just like just let it go. But I was pretty extreme. But okay, so let's get into it. What do you got for us first?
I'm sorry, I do, but I must. A lot of people are saying this about why are all these people appealing things and giving the board these vessels to issue bad decisions. One, the board is finding these exist. They're gonna exist.
Well,
The
ICE
board is gonna
officers are
issue what
appealing
it.
these a lot of that. I was that's
Yeah, ICE is appealing too. Right. In that case, you're right. ICE appealed that. Right. You're right. So my comment is not correct in response to you, but people are saying this. Like some of these bad decisions, why did the non-citizen's attorney appeal? Blah blah blah.
yeah,
If you got a client and they want to appeal, like you kind of got to
yeah,
appeal.
appeal, yeah.
Like that's what they got to do. But I don't believe the board is operating in good faith. We have a packed board. We have a captured board,
Well, we got
and I think they're
three
going
new
to find
appointments today.
three new appointments. I don't know anything about them, so I'm going to withhold my words until they start joining some of these decisions. But and they replace every single one of the BIA members who was fired for no legitimate reason was an excellent attorney, an excellent judge. So big shoes to fill there, and maybe not the fault of the board members coming aboard, but I inherently view them with suspicion where the attorney general has fired people for obvious political reasons, for reasons because they don't like their jurisprudence, even though they're following the law, and replacing them with people that apparently the attorney general does like. And so they're not they're not getting off to a great start, and that's not their fault. That is what happens when you delegitimize the courts.
Well, two of the three that are point I looked up their names, and there's this website called Track Reports, tracks all
Yeah.
the, and they
Mhm.
had like much higher asylum denial ratings than like I can't remember national average or their local court average, but it was in the night. It was like they deny like a lot. They were like main
Yeah,
denial.
and then I think the third might be coming from oil, so they wouldn't have any track rating. And yeah, look, track is good because it's the only metric we have. I do wish that we had more than that because I don't think asylum denial rate is necessarily
Captures the full
indicative
picture. Yeah.
of the judge, but it's all we have. So in that sense, but I think a high asylum denial rate is a prerequisite to get put on the board by Pam Bondi. So
I give the benefit of the
that's
doubt.
that.
They might be in a district where, because every part of the country gets different average asylum types cases. Because like in
Yeah.
California, you might have more Chinese and Iranian. In like Venezuelan cases, might be more in Houston, or so they might have certain demographics that lead to more types of cases out of denial or something like that. But it was interesting. One
Hey,
of
I'll
them,
always. Yeah. No. Yeah. Please
yeah,
continue.
one of them was a former Catholic Charities lawyer, private practice, won super lawyers and stuff. But then was there, and then the new situation with judges, be temporary judges coming in with no experience in immigration law. I've been doing this show with you for years now, and I wouldn't feel anywhere near. I don't even feel comfortable going doing a removal proceedings, being an attorney in a removal case, let alone the judge in it. And I'm like obsessed with immigration law. So
Yeah.
that's like really dangerous thing they're doing right there. Fire 100 people that knew what they're doing for the most part, and then hire a bunch of people
Yeah.
that don't know. Does that make sense? But it does make sense. It depends what your goals
Well,
are.
you got to be playing to the circuit. You've got to. At this point,
Yeah,
I'm not. UIR apparent. UIR does not care about the neutral adjudication of law anymore. If you get rid of 100 judges, whether it's through firing or forcing them out for various reasons. You fire the board. Yeah. So, but I'll to what you said before. I'll give any judge the benefit of the doubt. Everybody should, even if they knew him as an IJ. I'll give them the benefit of the doubt now that they're in the appellate capacity. Things change when you put on the robe, when you put on a different robe. But uh, I am inherently suspicious of any Trump appointee based on how the Trump administration has been acting. That's just how it goes. That's not the individual's fault. That's what happens when you delegitimize
The
the
institution stuff,
bench,
yeah.
the institutions.
Yeah.
But enough about that.
Alright, let's get into it.
OCV et al. V. Bondi out of the 10th Circuit on August 26th. It was summarized on my show with the decision, with the episode that I published today. Because I publish on Tuesdays now, so this was last week, but it is August and it's just too good. I didn't even realize it till I was like halfway done reading it because it's called OCV et al. This is matter of MRMS. Miss MRMS is the matriarch of this family. For some reason, she just wasn't the named petitioner in this family case. But this is matter of MRMS, the big bad BIA family nexus asylum decision that came out during Merrick Garland's board of all boards, which is just wild to me, in which the board instituted a new rule, quote, for family-based claims and family-based claims only. And by the way, this will be a bit of a theme on this talk today with these cases, that the board has been trying to create different rules for different classes when there aren't specific rules for specific things. They tried to do it with Silva Trevino and the CIMT definition. Like, there is the categorical approach, there is particular social groups, there is nexus, and then you apply that to facts. You don't get to create new rules based on family-based particular social groups. And that's exactly what the board did in matter of MRMS. Merrick Garland's board, quote, if a persecutor is targeting members of a certain family as a means of achieving some other ultimate goal, unrelated to the protected ground, like, gangs extorting, family membership is incidental or subordinate to that other ultimate goal, and therefore not one central reason for the harm. End quote. That's a new rule. Like, yes, mixed motive cases exist for asylum, but the protected ground, family membership, cannot be incidental or subordinate or tangential and qualify for asylum. The board is saying you can't have like any other reason for a family-based group. Matter of MRMS, big deal. I've been giving it no love on my show ever since it was published. It has not been faring very well in the circuits, and particularly the fourth and the sixth circuit have gotten their teeth into it. But this is direct petition for review. This is matter of MRMS. It was petitioned for review itself to the 10th Circuit, where apparently it originates in one of those 10th Circuit immigration courts. And the 10th Circuit was having none of it. They flat out said that rule, that's not how Nexus works.
Mhm.
Flat out, which is correct. And I do think indicative of how matter of MRMS is on the problem, quote, the government attempts to defend the BIA's Nexus statement, that is what I just said, by rewriting what the BIA wrote, end quote. So, like, even oil doesn't want this. And even in a generally favorable, 10th Circuit, whatever, it's not, you don't get that many positive for non-citizen decisions out of 10th Circuit. So even in the 10th Circuit, the oil's like, we don't want to do this. Like, that's not what the BIA meant. But if that's not what the BIA meant, they would have had no cause to make it precedential. Obviously, it's exactly what they meant. They wanted to do a new rule for family-based groups, and the 10th Circuit just vacated and remanded matter of MRMS. It's a huge win. Center for Gender and Refugee Studies, Perkins Coie representing the amicus of former IJs and BIA members, and AMICA, formerly the CARE Coalition. A lot of the whole community in on this one, and if that wasn't enough, because it's just I'm nerding out here. I have also been talking on my show, and I think a bit your show, this concept of zombie precedent. I didn't make up that term. I think David Isaacson or Jeff Hoffman did, now an IJ in Houston. That is this idea that when a circuit vacates a precedential BIA decision, that decision doesn't exist anymore. Other circuits can't rely on it. That's different from when, for example, the Sixth Circuit had already said, matter of MRMS, not good law in the Sixth Circuit, we disagree with it. Fine. MRMS exists in all the other circuits, but here the 10th Circuit has vacated matter of MRMS itself. That's different. I'm making this argument at present in an 11th Circuit case that goes to oral argument in December. Other people have been trying too. I've been talking about it for years now. It's my big nerd issue. And no circuit has yet recognized this, and I don't know why, but look at it. The 10th Circuit here kind of did. They said, quote, "We cannot leave uncorrected an agency's precedential misstatement of the law because that unlawful standard governs a dispositive issue and appears in a published three-judge BIA opinion, so it serves as precedent in all agency-level proceedings involving the same issue," end quote. And then the 10th Circuit goes on to explain why it's vacating before remanding. Why do that analysis if the 10th Circuit isn't saying that by vacating and remanding, MRMS no longer binds anywhere? It's wonky, it's complicated, but I see this as the 10th Circuit recognizing the zombie precedent argument, albeit not as fully and completely as I would like. But in any event, that's a lot. Big decision. MRMS appears dead. OCV et al. V. Bondi.
You mentioned one of the law firms working on it was Perkins Coie. I'm like, that name sounds familiar. That's the one that Trump went after when he
Correct.
came in.
Correct. Perkins Coie is the defender of all things good in this country now. Who would have thought? I'm not a big law guy, but Perkins Coie really standing up.
There we go.
And Wilmer Hale. I think Wilmer Hale defended Perkins Coie. So, there is quite the big law that stood up and fought back.
That's it's taking I mean it's groundbreaking the stuff that's happening with them. It just you never heard some stuff like this happen before. But yeah, again, the work done. So I'm glad that case is making a difference. So good stuff.
It's big stuff. And as I said on my show, if anyone is getting it, if IJs anywhere continue to rely on matter of MRMS, or if the BIA does, flat out zombie precedent petition for review argument. I've briefed it in the 11th. I'd be happy to work with you. It has become my pet issue.
Very cool.
And like I might be wrong because no circuit has ever engaged in this discussion that I'm aware of. The 10th Circuit kind of just a little bit did, but like I don't see how I'm wrong. No one has ever been able to explain to me why I'm wrong. Even in my own briefing, the 11th Circuit relegated it. The oil relegated the argument to a footnote, and then they mischaracterized the argument. That indicates to me that they don't have a good argument. So I can't let it go. It's
Well,
kind of like
if that
I can't
gets
let it go.
recognized, that not only applies to immigration law. There's other fields where they have admin law and that goes to the courts. So this will be like
That's
legally
true. I
groundbreaking.
don't know what all agencies do rulemaking. I think it's less so these agencies like the BIA that issue new rules through these case by case precedential adjudications. But yes, absolutely, it affects other areas of administrative law, and it would take down like 20 zombies. Josh Altman out in San Diego, he's interested too. He's put together a list of the zombies BIA decisions that have been vacated by a circuit. There's like 20. If the circuits agree, like 20 BIA decisions fall all at once.
This could be a Supreme Court case potentially. You take it all the way up.
I don't know.
Let's see.
I don't know. Sticking with asylum, then it's what.
Hey everybody, I'm gonna jump in really quick to get to Circle.so, our community page. I feel like I'm advertising some other company, but you have to know Circle.so is like a Facebook thing that also hosts video as a private community, all that kind of stuff. But it's the Immigration Lawyers Toolbox private community page. We're getting up there. We're gonna be 500 members soon, where we post a lot of private content that we can't put in public places because there's no lawyers involved, but it's all lawyers in the group. And if you want to join, it's free for U.S. lawyers. Just email me info@immigrationlawyerstoolbox.com with your name or your bar and your bar number, so know you're an attorney. We have a landing page for this too that you can fill in on our website, immigrationlawyerstoolbox.com/community, I think it is. And that way you get in there and see all the videos, training, white label, all the stuff we do that's free, hours and hours of content. But also our premium courses, EB1A, EB2, investor visas, a marriage immigration course. And I'm taking a chunk of that marriage immigration course, consular processing, adding EB and other NIV stuff to it too, making a standalone course. It's a lot of work doing right now. Every time I want to make 1,000 courses, I have so many plans, but there's so much work creating these courses. So the price tag is the reason for it. I spent a lot of hours on this stuff. Plus with the mentorship that comes with it, it's definitely worth it. So check it out there. Start with the free stuff. And if you want to join it, get your practice next level, do mentoring in one of the courses, just let me know then. But the place to go is to email me at info@immigrationlawyerstoolbox.com with your bar info, and we'll take it from there. Let's get back to the show.
Juan de Romero v. Bondi out of the Fourth Circuit on August 13th. I don't want to get too much into it. I just did a lot on asylum. It's another particular social group case, but it's interesting for a few reasons. One, the Fourth Circuit says it is ineffective assistance of counsel to assert a particular social group that has been rejected by that circuit. And it wasn't even the particular social group proposed here wasn't even directly rejected by the Fourth Circuit in the past. But to them, saying that your client is due asylum as a Salvadoran citizen whose spouse is gainfully employed in the United States is ineffective assistance of counsel because, like, adding the wealth-based characteristic has been rejected by the Fourth Circuit. I mean, I guess, like, I don't know. I personally think particular social groups are so nuanced that if you don't have a direct circuit decision on directly on point, I think it's hard to say that's ineffective assistance. But also, the ineffective assistance really is that attorney didn't assert other groups in addition to this wealth-based one.
Mhm.
And that's where this decision gets really interesting, albeit dicta. The Fourth Circuit says that there were quote, two other potentially viable options: the immediate family members, one, and women, or perhaps, I'm sorry, this is the quote, El Salvadoran women living under gang control, end quote. Quote, both particular social groups are likely cognizable under our precedent, end quote. Restated, Fourth Circuit is saying Salvadoran women living under gang control is a particular social group in the Fourth Circuit. Likely. So that seems like a big deal. And the attorneys who litigated this case, of course, recognize that. They posted that as well. It was published. Juan de Romero v. Bondi. Also, the Fourth Circuit recognizing that immigration law is so important that ineffective assistance will deny non-citizen due process of law under the right. So, assuming there's
So
prejudice. So,
does this make it where, I mean, as you said, they should have argued these additional features, so it would have been okay. But to a certain extent, could it be if this logic taken out? Like if you're an immigration practitioner, which is federal law, you got to kind of be mindful of where the person lives and which district it's going to fall under.
well, that's absolutely true. That's always been the case. I mean, particular social groups, categorical approach, really all of immigration law. It's the circuit that governs. I don't want to toot my own horn, but that's why my podcast is so important. Is that I'm doing the circuit law, and I've got it on the case page because it's even more so under Trump and after the death of Chevron deference. What the circuit says, that's the final word, whether it agrees or disagrees with the BIA. And if the circuit hasn't ruled and the BIA has, open issue in that circuit still, because the circuit hasn't ruled yet. Now, I wouldn't go all in on something that the BIA has said isn't going to work. I'd have other arguments too, but certainly shouldn't not make the argument until the circuit rules. And conversely, you shouldn't be making an argument, as allegedly, as the Fourth Circuit believes was the case here, shouldn't be making an argument that that circuit has said is not legitimate.
I mean, in my practice, the only real case is about visa waiver ESTA submission within 90 days in Ninth Circuit, where you get additional. That's the only court. I'm like trying to. I mean, if you're doing removal and humanitarian, that stuff that pops up a
But
lot.
that's always been complicated to me. I've never received a good answer. Like, I don't think any circuit applies there. Like, what circuit applies to things that are being adjudicated abroad by a Department of State consulate? I don't think it's guaranteed that it's just the residence of intended residents that governs. I think, nor do I think it's like where the NVC is physically
Uh,
located. It's a
That's like if you're living in the Ninth Circuit, and they your adjustment gets denied. If you filed it within 90 days, then you get a chance to get a second bite of the apple. You get a chance for removal hearings outside of just like filing an asylum claim or something like that. But the other circuits, I studied this. There's two
uh,
circuits that are kind of open to the idea, so they can still be argued in one of those circuits. Oh, sorry.
I'm sorry. So I misunderstood. I thought you said visa waiver. I thought you were talking about consulate. So you're talking right adjustment of status
ESTA kind of, yeah.
USCIS always in the circuit where the USCIS office is located. But I'm sorry. So what are you talking about with
So
ESTA?
there's a
If you get
case where typically if you come in on the visa waiver program, and actually I had a Department of State for a consular officer told me they learned about this from my podcast. I was excited. Okay. So like there's everyone's afraid of the 90-day rule, but like if you file for adjustment, marriage to U.S. that is an immediate relative within 90 days, even if you're on ESTA, Typically on ESTA, if you get denied, they can remove you immediately because you waive the right to court. But if it's in the Ninth Circuit and it's a media relative case, then you get a second bite of the apple to go to immigration court and potentially argue your case there for the whatever it is, the issue that led to the no.
Whoa, wait. First of all, is that only within the 90 days?
You have to file it within 90 days. Yeah. And
But
USCIS
still,
recognize the Ninth Circuit has this, but they don't recognize anywhere else. But there's a couple of
wow.
circuits that are open to it.
But still, you're saying that filing for adjustment within 90 days of entering on ESTA gets you out of asylum only proceedings
Yeah.
if it's denied? That's remarkable.
So that's why if someone comes to me in California, I mean, I'm like, you got to file within 90 days. They're like, no, I heard online it's not 90 days. I'm like, well, you didn't have the intent. You came. And so, like, if you just got married, do it within 90 days. I'll share with you after the show. But I was reading it again. I'm like, is that full on immigration hearings or what? But essentially, you don't get the automatic kicking out that you would on ESTA. So that's a,
Do you know the case offhand, or I mean, I
I
would
should,
be surprised if you.
I can look it up real quick while we're talking. Ninth Circuit.
No, that's. I mean, in any event, that's a very helpful thing to know.
Yeah, it's
Um,
I've said this the case a million times. I find it in 2 seconds probably, but, okay, so what's the next case? I'll in the middle of your talking, I'll bring it up.
That's good. Well, this is me wanting to tear up the BIA's decision, matter of Felix Figueroa, which I did on a Catholic Legal Services presentation last week. I mean, it's the BIA rejecting the isomer argument in the Ninth Circuit, actually, in a case arising in the Ninth Circuit, because the Ninth Circuit hasn't ruled on the isomer argument yet. This is the idea that drugs can be internally divisible. That federal marijuana, for example, is broader than Florida marijuana. The 11th Circuit and
Mhm.
the 8th Circuit have said, for example. So too with methamphetamine and cocaine. They're made of these things called isomers, apparently, other things too. The federal government criminalizes possession of only positional isomers, I believe, and a lot of states criminalize possession of all isomers. Now, the meth that people do, I don't do meth, but I believe it is made of the bad isomers that both the states and the feds criminalize, but that's not how the categorical approach works. I mean, if the states have more isomers, criminalize more isomers, you have an overbroad state drug vis-a-vis the feds, and so the person's not removable for that. Even according to the BIA in matter of Felix Figueroa, the Second, Seventh, and Eighth Circuits have made that exact ruling with meth. I think it might be more, but maybe that does sound right though. So this matter of Felix Figueroa, bad law in the Second, Seventh, and Eighth Circuits at a minimum. Here's my beef. This is the BIA trying to create a special rule for the isomer argument. That is, that if you want to make this argument, you have to find a case where the state actually prosecuted the overbroad isomer, the realistic probability test. I wrote an article for your magazine on this, although not an isomer specifically. And that's not how the realistic probability test works in any circuit except the Fifth Circuit. The BIA doesn't get to make a different rule for the categorical approach and realistic probability test with isomers as compared to any other crimmigration issue. That's just not how it works. They're making stuff up. And by the way, they're misreading lots of precedent, including the Supreme Court's Moncrief decision to do it. And I will not stand for it. I will die on this hill. In my opinion, matter Felix Figueroa is bad law in every single circuit except the Fifth Circuit. It has nothing to do with whether the circuit has addressed the isomer argument, which I'll agree the Ninth Circuit has not yet done. It did it and then it vacated it itself a long time ago. So it hasn't. It's open in the Ninth, the specific isomer argument. But the realistic probability test has been very much so addressed in the Ninth Circuit. It doesn't apply when the text of the state crime is textually obviously overbroad vis-a-vis the federal crime. So, you know, there's a lot of reasons to be upset with matter of Felix Figueroa. I don't believe the BIA, to use the term for the 10th time on your show, is operating in good faith with this decision. They just don't like the categorical approach. They just don't like the isomer argument. And they're willing to misrepresent precedent to get there. So we'll see how this fares in the circuits, because even before Loper Bright, the federal courts owed the BIA absolutely no deference. when it comes to the categorical approach stuff. So if you remember one thing, remember it's my opinion, matter of Felix Figueroa, bad law everywhere except the Fifth Circuit, which already had this rule, unfortunately, for non-citizens everywhere. So that's my 3 minute takedown of that. But yes, for now, bad decision. Gonna gonna be really hard for people in immigration court, other than the Second, Seventh, and Eighth Circuits for a little while. You got to be prepared to take it all the way to the circuit level.
Yeah, this isomer thing has always been funny. The thing from the beginning.
Hey, yeah, I mean, whatever. Like, there are so many technicalities that the government gets to get people removable. God forbid we get one too.
So real quick, the case I was talking about is Freeman v. Gonzalez, Ninth Circuit. Essentially says, and the USCIS did a policy memo about the fact on visa waiver, you don't get protections, all that, but they do talk about a visa waiver overstay whose case is denied by USCIS has no right to appeal and may not be placed in removal proceedings before an immigration judge. There is, however, an exception for cases filed within the jurisdiction of the Ninth Circuit. If their immediate relative whose I-485 was filed within the 90-day period of admission within the jurisdiction of the Ninth Circuit, they're entitled to be placed in removal proceedings under INA Section 240 should the application be denied by ICE. So that's like,
Wow.
yeah, it doesn't. I mean, it doesn't really come up that often. I'll probably hear about it if this is happening, but it's a good backup to have. So yeah, I have people who come like a week before the 90-day mark, like, yeah, my husband just proposed to me, and we're just, what do you do next? And I'm like, you got to get it in. I mean, the medical checkup's annoying now because you have to do a medical checkup with the filing. Before I'd be like, okay, just get an RFE or bring the medical checkup to the interview. But now you had to get the medical I-693 done before the 90-day mark. So it makes it tougher because a lot of times people just come on and then change their mind.
Do you? What? Why? I mean, I have filed. It's not our practice, but like we've gotten RFE'd for medicals
This
before.
stuff,
They don't.
they
I've never.
Biden in December 15th ish, he announced like you have to send the I-693 with the application or it's deniable.
Or their application gets rejected. That
Yeah.
hasn't been.
I mean, not
Well,
practicing it, but that's they updated it, and actually had a case right then where like we're about to file. I'm like, okay, go get the medical quick. So I called around, found the fastest person. We got it in like the 89th day, and so that was it. But
that's wild. That's good to know. That's a good thing to
there's a
know.
million and one things like this. It's I started by doing my top 10 episodes every Monday. I talk about Monday. I talk about something I learned this week, and it's like I've been doing it so long. We talk about this stuff all day, all night. It's our obsession, and there's still a million and
Yeah.
one new things that you learn every day. There's no there's no mastery. It seems like there's just more, and it changes too. So it's impossible to master because especially with this administration changing stuff every day. It's a
Well,
tough field to get in, but it's very
but it's
exciting.
fun, and this last decisions are one of the reasons it's fun. Fun. Hats off to Matt Adams and Trina Romuto and Nyla and all the Northwest Immigrant Project. It's a big case of Barra Perez v. United States, the Ninth Circuit, August 27th. Also on today's episode of my show, it's a Federal Tort Claims Act case for illegal third country removal. By the way, it happened at the end of Trump 1. This wasn't a Trump 2 third country removal. Essentially, as a Cuban, an IJ found he was transit banned from asylum, but gave him withholding. And the Ninth Circuit thinks that she misunderstood the transit ban. By the way, the IJ, I think it was a she, it could be a he. Anyway, he got withholding, but then ICE still sent him to Mexico because he had been in Mexico for a while. And when they were doing it, like he kept saying, no, I can't go to Mexico. Like I'm scared to go to Mexico and blah, blah, blah. So like illegal. They had to give him a reasonable fear interview. He had withholding. Um, he had to be given that opportunity. And then he gets to Mexico and he immediately gets threatened with death because I think his daughter wires him $100 and some gang sees it and all this stuff. And they actually let him back in. What a can you imagine some attorney gets wind of this and like they go to the border and the ICE lets him or CBP lets him paroles him back in for renewed removal proceedings where it goes before the same IJ. And by that point, the Ninth Circuit had vacated the transit ban, so he gets asylum. Can you believe it? And it's just incredible. But you can't imagine CBP paroling someone in, even when something terrible like this happens to him. But then he sued the U.S. government for the illegal removal. So the guy's probably a green card holder at this point. But like they sued
Yes.
because you got to give them a reasonable fear interview at a minimum. Uh, that's the interesting part of the decision. The rest of it was all about jurisdiction. I'm not going to get into it. But essentially, they sent it back to the district court judge to determine whether there had been an FTCA violation, because the government can't get out of this by just asserting the jurisdiction stripping provisions 212, 221G. Is it? I'm sorry, which let me get it. 242G, for example, it can't just, those don't bar the lawsuit. So that's a big deal. And I agree with Ira that FTCA and the willingness to go into federal court and try to get money out of the administration might be one of the only things that's going to stop them from doing what they're doing during this administration if they're doing illegal stuff. The FTCA. Yes, we've got yes, we've got habeas and other, and APA set asides and vacatures, but you know, God knows that Donald Trump thinks money
Yeah.
talks. So that's why this is exciting to me. It's in our circuit, the Ninth Circuit. It's a must read if you're going to bring an FTCA case, Ibarra Perez v. United States.
One note about CBP is one of the good things about the port of entries. You kind of have someone you can call and talk to sometimes in these cases, even though it's a national security zone. They don't allow attorneys get involved, but especially have a
Yeah,
G28 and you could just get hold of somebody. Sometimes you could talk your way into getting some help done. I have friends who go down the border, especially, and help with that. And then if you know your local CP office, you go to their ALA meetings and they're
yeah,
open. Some CP offices are shut. They're like, look at you like you're evil, like if you're a lawyer. But some are reasonable and they'll talk with you. And you can kind of accommodate people, especially if it's an existing client where you have the facts and the paperwork. So that people call me like they're the cousins, like, oh, my cousin's in the airport. I'm like, I don't know your cousin. I'm G28. And most of the time they're correct when they get expedited removal. The person's like, yeah, I'm coming here to work. And like, you're on a tourist visa. You can't do that. Removal or a voluntary withdrawal, whatever. But it's at least somebody, a lot of times it's there. It's an actual thing. It's not like the service center where it's a lockbox where it's
yeah.
impossible to get a hold of anybody.
That is counterintuitive, and yeah, far be it for me to slander CPP on your show. Maybe they are doing things like this even now. I certainly am not someone at the border working with them every day. So it's good that they did it here,
Yeah.
obviously. But on the other hand, look, it was an illegal removal. So it's good on Mr. Ibarra Perez and his attorneys for trying to get the government to own up to it.
Yeah, we got to do it. You got to do it. Well, thanks so much for sharing. That's interesting seeing some non-immigration immigration cases pop up, especially that one's going to be an interesting one to watch as it goes. So keep us posted.
Oh yeah.
All right, Kevin. Thank you so.
Well, hopefully it settles. He gets some money, and we never hear about
Yeah,
it
that's probably the
again.
best way to happen. I mean, for lawyers, sometimes you want some good precedent that are slapping around of, hey,
Yeah,
the judge like, say, what'd you do?
yeah,
You like seeing that, but
yeah.
whatever's best for the client. If you want to catch Kevin, the Immigration Review podcast is there. Pretty much number one in the game right now when it comes to immigration podcasts. So the king right now. You got number one. I'm behind you, but I'm
You're
catching up.
too kind. I'm not sure. I don't know what your man. I don't know how you could even know that. I appreciate you
I
saying
just
that,
I
but
just
like,
search on podcasts and I type in immigration. You're always on top. I'm like that used to be me.
who knows? Who knows? Who knows what the algorithm is doing? You and me, we both get those emails from podcast people.
Yeah.
I don't know who's ranking anything, but
Well, you're doing
in
something.
any
Everyone
event,
knows
I'm
you,
glad.
and you're doing hard work. The one thing is like when you put a lot into like you do of studying this stuff. I mean, it's not easy creating your podcast. You're putting the yourself into it and the time. So it's obvious. It means a lot to people from when I talk to them, they listen and stuff. So I appreciate what you're doing and adding to the field.
You as
Appreciate it,
well.
brother. Thank
Thank you,
you.
John. It's a pleasure to be on your show.
All right. We'll talk soon. See you next month. And thanks for sharing that information. Immigration Review Podcast, found wherever immigration podcasts can be found. Well, thanks everyone for listening. What a great episode. I learned a lot. Kevin learned some stuff too. That's all it's about here to share information because there's an infinite amount of information in immigration law practice. So, and a lot of people are small or solo practices, and it's good to have this kind of brain trust to kind of reiterate all this new stuff because you may not have people to bounce ideas off. I have my associate in my own practice, and she'll catch stuff and bring it to my attention on her Slack page. And then we have like of counsel as well, always Kazi, that comes and helps out on cases sometimes. And we have a 3-person lawyer chat that we're like, oh, did you hear about this? Did you hear about this? And it's great to have that, but not everyone has that. Either small or solo. But this podcast really serves as that as an open forum to really listen and also feel like you're part of the group. And hey, share your information with us. Come, share an article, talk about your niche experience, so that it's a niche or niche, whichever one, but that could help other practitioners come better. And that way you get more attention to yourself too, and promote yourself and your firm, get more business, and everyone wins. That's the beauty of this abundant mindset kind of concept out of Immigration Lawyers Toolbox. Just help everybody, and I get help too. It's pretty fantastic. So definitely jump on board. Until next one, have a good one. If you like this episode, follow us on Instagram. Our handle is Immigration Lawyers Toolbox, where we post the latest statistics, tips, and more. And stay tuned for more from the Immigration Lawyers Toolbox podcast.